guys, a custody battle that starts off sounding routine, but quickly reveals deep control issues and broken communication. From the opening moments, you can sense this isn't just about visitation, it's about power, silence, and who gets to decide when a parent matters.
Any scheduled or ordered visitation, again, yes, I do have the right to say no to him. And why I brought this fully to you, instead of agreeing, with when I had Miss Hesse, is so I had the restraining order on Mr. Staley, and that ended at July 2022. So right after that, because it was again my son's birthday at that time, he came over and started coming over every Saturday until October 29th. He did this. I left most days. Some days come and go, but I mean, they had their time in my house the whole day. He never took additional time, not even when our son was hospitalized during that time period. And the 29th is actually a Sunday. He did attend, I threw kind of like a family kids Halloween party. His nephew was there, our son's best friends. He attended that and then did not attend trick-or-treating with the kids as he had set up with them to do. And we didn't hear from him again until Friday. He called late at night. I didn't answer. My son did. We were having like a movie night. And the first thing he said is, we're not going to see each other for a while. And, I watched my son take that call. It wasn't very long. That's pretty much what he said, just like that. Gave him a few reasons when he asked him why. And they have not seen, heard from, been sent, called, a text message, nothing from Derek since then. And so I guess I have other things I would like to address, but that I don't know, that just feels so forefront to me. I as Miss Orchard has said, he wants to be like he's been working towards being more reliable, etc. He hasn't. Where has he been? He's not been kept from them. We didn't even argue. He came, to our Halloween party, and was there the whole time. And we just we got the phone call later in the week and never ever have heard from him since.
What did your son convey to you as his rationale?
I'm sorry, could you maybe what my son thinks of it or how he took it, or
what his dad told him, why he wasn't going to be seeing him for a while?
He's used to that. He's getting pretty good at taking that, actually. He asked why, he cried. I kind of sat right next to him, kind of like deciding if I should interject or not, but Derek was explaining himself. Derek said something about he's sick in the head. He needs to go somewhere to learn how not to be. How it's kind of like a school buddy. And then he compared that to going to school. And that's where I kind of motioned to my son, like, okay, babe, it's okay. Maybe we'll talk to him later. He told him he'd call him whatever time frame he said he'd call him. He never did. Not once. Your Honor, not once. Nothing.
Okay. Tell me what your current situation, and I haven't had you under oath. That was sort of, I guess, as an attorney, I guess you're making an argument, but raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right. Give me a little bit of background. How old are you?
I'm 30.
Okay. And where are you living, generally speaking? What town or close to what town?
I live in Benton, in town in Benton.
Are you working?
Yes, I work full time.
does anyone else live with you besides the boys? Do you have any other children or a significant other or new spouse or anything?
No, I've been single this whole time, raising the boys and working alone.
Have you received any child support or goods or anything from him?
I do receive child support. It's $74 and change. Sorry, 75 biweekly. I will say that's been regular since February. From October, well, I guess I should say November. From the beginning of November to the beginning of February, I did not receive any payments. That's when I had messaged Derek in January, kind of like, what are you doing? He's had my phone number this whole time. He left them. He left them. And he says he's been kept. And I don't know what the appropriate composure is as someone representing myself and a mother, but it's not right.
The case turns emotional and uncomfortable as Mom explains how the children were left confused and hurt after their father suddenly vanished. Hearing how the child processed that phone call shows the real impact court orders don't always capture. Should emotional damage like this carry more weight in custody decisions?
It's not right to do this.
Okay, I'm gonna allow some cross-examination by his attorney. I do understand totally what you're saying. I think it's rational and justified, but I can't change the fact that he is their father.
What should we,
I don't know yet, but I promise you that I will make sure that he is consistent in whatever it is he's doing. I also will tell you that dealing with criminal cases as well as civil and domestic cases, there are folks that sometimes are in no shape whatsoever to be around their own children. And so if they step away and they're doing something productive like treatment or that kind of thing, then that is better than them being around the children. Even if the children don't understand, it's better than exposing them to an active drug addict or someone who could potentially harm them intentionally or unintentionally. Having said that, there would be nothing that would prevent him while he's in treatment or recovery from sending a card or writing a letter or something more far removed like that, just to let them know that he's alive and well and loves them. So let's hear from Mr. Staley after his attorney, Ms. Orchard, has the right to cross-examine you on some of these issues that you've raised. As the impression I get is that you're wanting to suspend visits altogether and remain having sole custody. Is that your position?
Yes.
Okay. All right. Ms. McKenzie.
So your testimony is that my client never reached out to you to see the kids.
Yes, not
October 2023.
I was asked once. His father, who has always been allowed open communication and visits with them and does them, it was either the day before Christmas or Christmas Day, 2023. He had made plans with me to have the boys for the day. He came to my house. As he was leaving with them, he asked if he could take them to see Derek, even though we'd already discussed how Derek had been away at that point for 2 full months without communication. And I never, up to that point in my doorway, had any communication from Derek. So in that moment, yes, I said, no, Marlon, you have your day, and, Derek needs to communicate with me. And then when I messaged him January 4th about kind of just, where are you? Also, there'd been no child support. His reply was, I have them. Just give me one moment.
That's okay. You've answered my question. So your testimony is that since October, he's not ever asked to see the kid.
No, he has not asked. Well, I'm not, if I could finish actually. On the message on January 4th, because I want to be
short answer question. I will get to the messages. I'm asking, just making sure that you're saying.
It's a part of completing the answer to your question.
It's a yes or no question. It's just yes or no.
Okay. I'm gonna overrule your objection and allow her to finish answering, but keep it brief, please.
Okay. No, it's not a full read off. It's that I said, were you planning on paying anymore? No, just wondering. It's been 2 months, with nothing from you, including communication. He said, yeah, I'm working again, and I'm going to say this, and that's it. I want to see the kids. I want them to come over. Again, because you want it brief, I could go on. I never even said no in those messages. I was more in shock that he truly believes he does not have to even speak to me in order for me to just bring over and drop off the kids again at that point,
Okay.
over the 2-month mark without communication.
Okay.
Besides that, no,
That
not at all.
your last communication, January of 24, before this motion was filed in June?
I did message him the other day. I asked him to come and speak with me and did not do this report. He didn't respond. Other than that, no communication.
Well, okay, so you can't do that anymore. You're representing yourself. He's represented, so his attorney will tell him not to visit with you about the case or make any agreements or anything outside of her knowledge and involvement.
Sorry, I mean, it wasn't malicious or anything. I didn't mean anything by it. I just genuinely would rather not do this. This is not natural, and I don't know why.
Okay, Ms. McKenzie, your next question, please.
So I'd just like to, so you say you never said no. The text message right after the one you just read off says, you're right, no child should ever have to ask where's my dad, but ours have to regularly. I have the right to say no. LOL, mind boggling, really. So you did say no.
I didn't really necessarily get to answer. How can I answer drop off my kids now to someone who has not seen them in 2 months? If you want to be quite literal, I mean, it's more a statement of, I do have the right to say no. Further conversation would have produced a direct answer from me, but I did not.
When child support numbers and missed payments come out, it reframes the situation from emotional neglect to financial responsibility, adding pressure that can't be ignored. Do financial gaps like this change how you view a parent's commitment?
I didn't get that.
Just for fairness for the court, since you didn't read all of his message, he said, I'm going to say this and that's it. I want to see the kids. I want them to come over. I am setting up court so I don't have to fight with you to see them. I would love for them to be able to see me before that, but I won't fight with you over it. If not, then I will wait. They shouldn't have to ask you. I shouldn't have to beg you. I am their father and will always be their father. That will never change. To which you replied, you're right. No child should ever have to ask for my dad. But ours have to regularly. I have the right to say no, mind boggling, really. So he did ask, and he didn't say drop them off now. He asked to see the kids, but he did make it clear that he didn't want to fight with you about it. He would go through the proper legal channels. Is that correct?
Because I have sole custody ordered without any scheduled or ordered visitation, again, yes, I do have the right to say no to him. Specifically, I would say even though I did not say no directly to him, I wish to communicate with him during this message and arrange further visits. We didn't get to that. But in hindsight, at this point, I would consider myself saying no in hindsight. That's not the answer he got in that moment. But that is because my reasoning for needing more than I want my kids now and I head over with them. I need more than that, as again, the parent was sole custody and he has no visitation at that point. He took a 3-month period of where I allowed him visitation,
All
and
right,
then
wait,
without seeing
wait.
them, with no communication. He did not
Okay.
communicate with his children for 2 full months.
Ms. Taylor, you need to be more responsive. You're not being responsive, and that's not fair to the attorney. It allows her to object, and I need to sustain the objection and strike the unresponsive answers. Ms. Orchard, did you put your exhibits into Odyssey or something? Because I have no exhibits.
We emailed them, but I did not e-file them with Odyssey. No, I did not. If you would like, I can call upstairs one of our assistants to do that if you'd like, but we did email them to Amy.
Okay, when did you do that?
Yeah.
We emailed them before the first hearing was supposed to happen. Then obviously it didn't happen, but then I emailed them again today in case you didn't have them from the last time that.
So what I want to know is specifically, do you, Ms. Orchard, do you have documentation of where your client was from October to January in terms of treatment, therapy, that kind of stuff? Did it coincide during that time?
Yes, it did coincide during that time. I don't have his medical records, but I can request them from Holland Pathways if you would like.
Okay. I think that's going to be important to me in evaluating this, in seeing the exhibits and saying, okay, if someone walks away because they feel that they're not in a good place to be around their children, and kind of, he should have let her know, not, and maybe approach the son a little bit different way. But the point is, if someone walks away for a few months, but they show that they're doing things to improve themselves and they actually have improved themselves, then that's something I think that the court can or would consider as not necessarily an abandonment situation or a bad thing. Again, I'm not sure why there was no card or no anything, but if he was getting help and struggling with his addiction and his mental health issues, and he can demonstrate what all was going on with him during that time, that is going to make a difference to me. So I think, and then I think the approach should have been very different. I think that he should have, I mean, the court ordered him to do certain things. He should have at least communicated with the court, provided proof or an affidavit that he had done the things the court asked, and let mom see that so that she knows what he's been doing. But I think what I need to do is schedule this for an in-person evidentiary hearing in my office with the exhibits. I'll print out the ones you have and I'll give you time to add to them. In all fairness, for all parties involved.
Could I say something for that time frame?
Do what?
How you wanted to focus on the time frame he was gone, you know, what was he doing? And you cut that off at January 4th. That should be extended at least to the day I received papers from him in June. from October to June, he made no effort to communicate with his children. The message in January was first instigated by me, and that was his response. Again,
Well,
he doesn't
stop.
speak to them.
Miss Taylor, are you not listening to me? Can you not hear me? When I say stop, I mean stop.
The judge steps in with a reality check that hits hard, explaining the difference between abandonment and stepping away for treatment. This moment is crucial because it shows how courts try to protect kids while acknowledging mental health struggles. Where should the line be drawn between healing and parenting?
I do hear you.
Now, I'm going to schedule this for a full evidentiary hearing. It's not going to be a proffer. I kind of thought that what would be argued today is what the parties agreed to and announced that they were in agreement to. And then Ms. Taylor withdrew her consent to the agreement, so that there might be an argument in that regard. But it seems like we're starting over from scratch where we were when we scheduled the first hearing that was canceled. And so I'm going to get it scheduled, and it's going to be in person. Now, whatever I do, Ms. Orchard, I'm sure that you can appreciate is going to be, if I grant specific visitation, is going to be a gradual reintegration. Whether that means Saturdays or every other Saturday, and no overnights, or even supervised, or whatever the case may be, you know, it's not going to be just jumping into extensive, unsupervised, lengthy visits. I mean, he obviously has something to prove to the court in terms of his commitment, because he's either in or out. I don't know, I don't know if you can get the medical documentation of his, you know, all I really need is, I don't really need all of his reports as much as admission dates, discharge dates, therapy dates, you know, kind of a trail of what was consuming his time. I suppose July 30th would probably be too soon, counsel.
If I may ask my client, Your Honor, real fast. My client thinks he can get the documentation that the court would like by then, so July 30th, I think, will work.
Okay. Do you prefer July 30th, or do you prefer Monday, August 12th?
It depends on what time. I'd say I actually will be up in Butler County on another case for a hearing with Judge Hart on the 30th in the afternoon.
Okay.
So it would depend on which time. The other day was the 12th, Your Honor.
Yes. Let's go ahead and do the 30th from 9 to noon. Ms. Taylor, do you have the boys in counseling with someone by chance?
No.
Do you have any interest in putting them in counseling?
No, I don't. That's, you know, I provide them the home and life that they, you know, need. Life's not perfect. I don't believe they need, you know, weekly counseling.
Okay.
We live our life. We go on.
Okay. Are they on CanCare insurance?
They are.
Okay. Ms. Reddy, did you have something?
Yes, Your Honor. I was going to ask if the court would order Ms. Taylor to complete a DRA. That way I could complete an updated child support worksheet prior to that hearing. I would also ask to be excused given that the issues are parenting time. And if the court would like to resolve child support, I think you could probably do that if I propose a worksheet ahead of time.
Okay. Very good. Yes.
Thank you.
To all of those things. So, Ms. Taylor, do you have an email that Mr. Hardy could send you, or Amy could send you a blank DRA that you could fill out and email or mail back?
Yes, it should be the one I've received correspondence through before, including today's Zoom link.
Okay.
I have
So
that.
we will send you or give you the direct link to fill out an amended DRA, and then that will be used for child support purposes to get that computed and get that reinstated. Or he's already in, I mean, it's already set at an amount, but we need to see if it needs to be modified.
Okay. Yes, I
Okay.
can.
All right, thank you. All right, let me know if there are any issues, but otherwise, I apologize. This is important enough that it needs to be done in person. I can hardly see you, Miss Orchard, or your client, and I think that he deserves to be heard in the courtroom under oath, and I think that Ms. Taylor deserves to complete whatever portion of the case that she wants to complete, and I think
This is peak courtroom tension as private text messages are read aloud and contradictions surface fast. The judge repeatedly shuts down unresponsive answers, and suddenly, credibility becomes the real issue on trial. When messages say one thing and actions show another, who should the court believe?
they deserve to have a courtroom hearing. So, okay, if there's nothing further, we're adjourned today.
Your Honor,
Thank you.
could I request something?
Yes.
It is the oldest child's birthday tomorrow. Is there any way that the court would allow my client to see the oldest child just for even an hour or so, even if it's supervised? He just would like
Yeah, I'm not doing that yet until I hear everything that's been going on with him and I evaluate him. And part of that's just seeing him and talking to him and hearing from him. And I need to look at your exhibits. I'm not comfortable with that. I don't know if that would be traumatic or not. And I just don't want to run the risk of it being traumatizing or real upsetting on his birthday. But I will allow him to do a card and a present and give that to his dad and allow his grandpa to bring it to the oldest.
Okay.
I'll allow that. To me, that's a great start, is a card. And maybe if he can't afford a gift, then just a card, but some kind of recognition and something from him would be fine. But I'm not going to, I'm just not going to go out on a limb and do some temporary things because of the serious nature of all of this and me getting a better perspective of it.
Understandable. I had to ask. Is
Okay.
it okay if my client's mother does the dropping off? My client's father, I guess, lives in Texas, so he wouldn't be able to do that easily.
I haven't seen her for a longer period of time, with equal lack of communication.
Well, so Grandpa hasn't seen them for quite some time.
Grandpa is allowed to see them whenever he wants. He lives in Texas. He just saw them 2 weeks ago. He came down. He went fishing in Glen Elder. And that morning, last minute, that made it work. Later that day, he spent the evening with them and did fireworks.
So, but you don't have any reason to believe he's going to come see him for his birthday or anything like that?
No, there's no plans. He couldn't get off for work. He was invited to be here tomorrow or for the party this Saturday. At this point, I have no communication with Mr. Staley's mother. The kids have none as
Well,
well. I'm
understand,
sorry.
understand that you could end up putting her in a position where she's going to file for grandparent visitation rights, and she's got some potential entitlement to that. I don't think we want to get her as an interested party in here where I've got to evaluate her fitness. She is going to be entitled to see the children during his visits, or if he's not authorized for visits, her own time. So just keep that in mind. But is there an alternative of where this stuff could be dropped off? It
Could I
could be, can't be
one-
missed, I guess. And it needs to be tonight or first thing in the morning.
Could I ask one question?
Yes.
Because I need clarity so that I can have the right mindset. If a grandparent has made no communication for, well, about a year now, what rights would they have to
Well, it
demand?
depends. I would have to have an evidentiary hearing and see what the extent of bond is and what the
She has no bond with them. She has no bond with them.
That-
She does
okay,
not-
that's something that I would have to evaluate. So do you have an alternative suggestion of how he can get a card and a gift to your son?
Just if I could just think,
What about your parents?
my father lives in Texas as well, and my mother is not in state either.
Do you have a mutual friend or a coworker or someone?
Again, I haven't even spoken to him since October. We don't have any mutual anything. There's been no communication from anyone except the grandfather who lives in Texas.
Well,
I'm not sure what to do about that. I mean, it's the day before the birthday, you know.
If I may, it would just be dropped off on the porch. If that's fine, we can do that.
That's
Yeah.
fine. To drop off presents in a cart is fine. My mindset is always that these little bursts, they are harmful to the children. To see them in the, just on the birthday, just on the Christmas, just to explain my apprehensiveness. But sure, you can drop off the gifts. Brenda, if I can bless you, you can drop off the gifts.
I hope to allow
you can say hello to the kids, but she hasn't in
Caleb,
over a
can
year.
you not hear me? Stop.
I think there's lag. I'm sorry. I think there
Okay.
is lag.
There must be. I'm going to allow his mother to drop off a package and a card on the porch. Not him. I don't want him on the property. I don't want him accused of anything. I just don't think that's a good idea. If there was a Benton Police Department, that's probably where I'd have you go, but I don't know these days whether the sheriff is contracting and doing the work or whether Benton has a police department. So I think this is fine if she just goes to the house and drops on the porch and takes a picture to show that she dropped it on the porch, which should have the time and the date stamp. And that's about all we can do at this late hour.
What is
Okay.
your opinion? Should she visit them or not? I will do.
No, I
what you think
said drop it
should.
on the porch. I'm not ready for anybody to visit them until I have a little better handle of this case.
The judge draws firm boundaries, denying a birthday visit, demanding proof, and ordering a slow, structured reintegration to protect the kids. This ending makes it clear stability comes first, not emotions or timing. Was the judge right to say no on the birthday, or too strict? Like the video, subscribe to the channel, and we'll see you in the next one.